Okay, good afternoon, everybody. I'm Brian Dodge with the Retail Industry Leaders Association. On behalf of RILA and our legal arm, the Retail Litigation Center, I'm really pleased to welcome you here today. Today is a very important day. This morning, the U.S. Supreme Court heard oral arguments in the case South Dakota versus Wayfair. The case represents the latest front in a years-long battle to restore free market competition, to require online retailers to do what Main Street retailers do every day, collect and remit sales tax on purchases where the sales tax is due online. And I want to emphasize that, the sales tax that is due on purchases made online. While it may still come as a surprise to some, since the dawn of the internet, virtually every transaction that has occurred online has been subject to a sales tax. However, a loophole has allowed out-of-state online retailers to avoid collecting this tax. As a result, even when Main Street retailers can match or beat the prices of their competitors online, the requirement to collect and remit sales tax creates the appearance of a better deal online. For nearly 2 decades, retailers have fought to close this loophole, first in the States, then in Washington, D.C., and again in the States, which is where today's arguments started in the case that was considered before the court. In a moment, I'll introduce the first of 2 panels to talk about how we got to where we are today and what will likely happen if the Supreme Court upholds the South Dakota law. But first, I want to acknowledge some of the people who have played a role in bringing this issue to where it is today. While the issue has failed to move through Congress, it's not for lack of effort. Specifically, Senators Durbin, Alexander, Heitkamp, and Enzi and their staffs have been remarkable champions for this issue. So too have many in the House of Representatives, including Kristi Noem, Steve Womack, Jackie Speer, Peter Welch, and many, many more. We are grateful to all of them. And to the retailers, small and large, and industry partners who have weighed in with policymakers, some are here today and many more are watching online, you've played a critical role in getting us to where we are today, so thank you. In the states, the work undertaken by so many of our partners in the state retail associations on behalf of the entire industry has been tremendous. I want to welcome one special guest who's with us here from the states, Sean Lyons. Sean is the president of the South Dakota Retailers Association. Sean has been a great advocate for retailers in South Dakota, and we're glad to have him and his wife Stephanie with us here today. We wouldn't be here without you. And finally, I want to thank the state of South Dakota, specifically Governor Dugard and Attorney General Jackley, for their commitment to fighting on behalf of Main Street. So with that, I'm pleased to introduce our panelists to discuss how we got to where we are and how the South Dakota bill changed the game. First joining us is South Dakota State Senator Deb Peters. Senator Peters was elected to the South Dakota Senate in 2010 after 6 years in the State House of Representatives. Senator Peters is a senior assistant majority leader and also serves as the president of the National Council of State Legislators. But perhaps most relevant to today's conversation, Senator Peters is the one who introduced SB 106, the law that the Supreme Court reviewed today. Without her, we are certainly not here today. On behalf of the entire industry, we thank you, Senator Peters. Second, I'm pleased to welcome Joe Crosby. Joe is a principal with Multistate Associates and a nationally recognized expert on state and local tax policy. Prior to joining Multistate in 2011, Joe spent 11 years with the Council of State Taxation. Joe has been a valued partner to all of us in the retail industry. And finally, our moderator today is Bernie Becker. Bernie is a tax reporter with Politico Pro, where he is primarily responsible for writing the morning tax tip sheet. If you're not receiving this, you're missing out. Bernie has covered taxes in the past for the Hill newspaper, and over his time has covered the campaign to level the sales tax playing field in its many iterations. I think he's the unofficial dean of the e-fairness beat. Please join me in welcoming Senator Peters, Joe Crosby, and Bernie Becker.
So good afternoon, everyone. Thanks for joining us today. It's a busy tax day. We've been wondering whether the Supreme Court had a sense of hearing in having this particular set of arguments on tax day, but who knows? I guess that's up to them. So this first panel is going to be about sort of how we got to this point. This is sort of the pre-April 17th, 2018 panel. So let's just get right into it. I guess the first question is, this precedent they were discussing today is a half century old, maybe. Depends on how you look at it. But sort of describe how the sort of rise of online shopping has sort of changed the sort of arguments over the physical presence standard.
So it's interesting, Bernie, when Quill was decided in 1992, the internet was still not open for legal commerce. And so the court didn't have the issue that it had before it today then. When the Congress passed the Internet Tax Freedom Act in 1997, it was amazing. I think I probably fielded 100 different calls myself from reporters who thought that that meant the internet was now tax-free. And so the same thing that Brian said in introduction, that myth still perpetuated, while at the same time electronic commerce grew dramatically, not just business to consumer, but also business to business. And many individuals were unaware of their compliance obligations and still today are not and do not follow them. And so I think that the biggest change has simply been the growth of electronic commerce and the need to update our tax laws for a modern economy. If you read the Quill decision, the court acknowledges it probably was wrongly decided in 1967, but they were going to leave it as it was simply because that's what they had said then. It seems to me 50 years later, given the changes of the economy in the intervening period, it's time to finally update our laws.
I guess I'm not going to have to add a whole lot to that conversation. As commerce changes and how business changes and how consumers consume products in this country, our tax laws must keep up. And that's kind of the reason why we need to address it.
Can you talk about why this is a particularly pressing issue for your state?
Sure. Well, the state of South Dakota, we don't have an income tax. We don't have a business income tax. We don't have a personal income tax. About 80% of our general fund revenue for the state of South Dakota comes from a consumption-based tax system. And in order for us to fund roads, bridges, teachers, healthcare, and anything else protecting the public and protecting those who can't protect themselves, it has to be funded with our sales tax or our consumption type taxes. And what we have seen over the past 20 years is an erosion or a slowing of the growth of the revenue. Now, what we have done in the last couple of years is if we needed to raise money for a specific purpose, we have raised that tax. So Senate Bill 106 was not intended to be a revenue grab. If we needed money for a specific purpose, like we did in 2016, we raised taxes to fund teachers. We raised the tax, the sales tax, in order to fund it. So Senate Bill 106, the entire intent is really to ensure that the erosion of the tax base, so to ensure that is to prevent the erosion of the current tax base, and then if we were to rein in some additional resources from Senate Bill 106, it would roll back the tax rate. So we maintain a broader base so we can lower the rate.
Can you talk about how South Dakota became sort of in the pole position to be the one arguing this case in front of the
Well, in the beginning, and Joe can probably address this, but in the beginning I was told South Dakota could not be the leader in this without a law change. And so we pulled in, we talked with all sorts of tax organizations. We talked with a lot of tax attorneys. We worked with the retailers, and we tried to figure out, well, what would it take for South Dakota to actually take this charge? I mean, Sean Lyons and his organization was critical in South Dakota to start bringing together some people. But with the National Conference of State Legislatures and with Joe Crosby's group and with RILA, and we were able to pull together the resources in order to come up with a mechanism for South Dakota to become the leader, and it came with Senate Bill 106. We had to change. The fundamental reason is we had to change the sales tax law in order to ensure that we had a direct challenge.
Okay. One of the sort of, I guess it's not a quiet elephant in the room, but one of the elephants in the room is Amazon, just given the way that President Trump talks about them, among other things. Joe, can you talk about sort of how having sort of really big online retailers sort of affects this debate, if at all?
So I think Governor Jackley in today's arguments actually talked about this well. There was contention that because 19 of the top 20 largest online sellers are collecting sales taxes, this isn't really an issue. When you look at that list, it includes a lot of household names, from Amazon to Walmart to others. But when you look down in the GAO report that was referenced today, made this clear, of the next 900 retailers of the top 1,000, the next 900 largest online retailers, fewer than half of them are collecting tax except in one state. And so when you look at commerce overall, I think the key thing is that there is a single rule that is easily administrable and easily understood. And South Dakota Senate Bill 106 creates that with a bright line threshold so that every retailer that's doing business in the state knows when it's time to collect sales tax and when they don't have to.
And sort of one of the arguments the other side was making about this is that it's almost like a self-correcting problem, right? That over time, as sort of the, if the argument is that online commerce is growing, then more and more states will, or more businesses will have nexuses in states, and then this will sort of essentially solve itself over time. Can either of you sort of discuss your issues with that line of thinking?
I guess from my perspective, small business, well, one, the court this afternoon or this morning was talking about what the definition of a small business is. What is that? That's a really tough question to answer because every state is going to have a different definition of what small is. South Dakota, we're going to be smaller than the average, in my opinion, because we have smaller people, or, smaller population of people. But when it comes to how to deal with what creates that nexus, what creates that in order to be a taxable retailer? Well, you could be a wholesaler. Well, is that wholesale situation where you have inventory in one state and you're selling it? So all you're doing is drop shipping it. You're taking it out of a warehouse, let's say in Minnesota, and you're drop shipping it into Nebraska, but you're the wholesaler located in South Dakota. What point is that a taxable transaction? And so that's a fundamental question as far as what is the definition of nexus? Because that creates physical presence, but does physical presence decide, even though you don't actually have physical ownership of the inventory in Minnesota, does that create the ownership? Because you buy it, and with the just-in-time inventory type of scenarios, you don't actually have to have inventory on hand as a small business. You buy it when you need it, and you ship it where you sold it. So you have to come up with a conversation as far as what is the definition. And if you're just one person, and you could do hundreds of thousands or even hundreds of thousands of dollars worth of transactions and just have a one-man shop. So what's that definition? And so in South Dakota, we made it a clear, bright line test on what actually is small business.
I also think the contention that it's a self-correcting problem misunderstands the problem. Yeah. Certainly revenue is part of this, but the larger problem is that we have an unlevel playing field with a federal rule that preferences certain retailers who arrange their affairs in a particular way to limit so that their activities into a single state. And that can't be self-correcting. That rule will continue to inspire some retailers to arrange their affairs in a way that's not necessarily the most economically efficient, but that meets this rule so they can have a price advantage over other retailers. And so there's the two components there, and it's not self-correcting if you're the retailer who's competing against an online seller into the future who is not collecting sales tax.
So certainly here in this town, you sort of can't discuss how we got here without talking about the role of Congress. In the Quill decision 26 years ago, Justice invited them to legislate on the issue. They haven't done so. There was some talk in the arguments today that some of the lawmakers were making the case in their briefs that they are sort of getting closer and closer to that point. Do you think, talk about sort of how this has been gridlocked in Congress over the years, and whether you think they are as close as some of them were saying they are to getting legislation across the finish line.
So having been involved in this for 20 years, I don't think that they have moved at all in the past 5 years, at least in the House of Representatives. Chairman Goodlatte has never even introduced a bill. He's had a statement of principles. He's put a draft out there shared with select people, but he's never actually introduced a piece of legislation, held a hearing on a bill, taken it to markup, and moved it through. The Marketplace Fairness Act passed the Senate in 2013 on a bipartisan supermajority vote. I think it was 73 votes or something like that on final passage. I know that there was discussion following the decision today that they were really close but for the court taking the case. Well, interestingly, just this morning, the court announced a decision where after oral argument and prior to a decision, Congress had changed the law in a case involving Microsoft. If the chairman thinks they're that close, they should just take the Marketplace Fairness Act, which already passed the Senate, put it on the floor to bring it for a vote.
I would just tell you how it's very frustrating being in a legislature that, we're only less than 40-day sessions. We have to do a ton of information. We wade through lots of information, lots of bills, lots of tax policy, and we get through our business in less than 40 days. And to watch Congress not fix this issue that they were directed to back in 1992. And, we've done, at least 24 states with streamlined sales tax have done what was asked in 1992. We simplified our tax laws. We simplified our definitions. We've coordinated with 24 other states. And so we've done what it has taken in order to do our end of the bargain. And then, we as states, through the National Conference of State Legislatures and Streamlined Sales Tax Governing Board, along with our retail partners, have been up in Congress. We have been walking door to door, knocking on doors. We've been meeting with not just staff, but congressional members, talking about this issue and continually educating people on how important this issue is to the states, to not have anything happen. We have a lot of really good friends, and they were mentioned in the opening remarks. We have Congresswoman Noem and Congressman Womack that have been really good allies of ours on this issue, but have not been able to get it through the Judiciary Committee. And that's a very frustrating avenue to know that Congress, if they have one person that can block something that we know has a majority of the support, that doesn't happen in South Dakota. Every bill that's introduced gets a hearing. Not one person can block one bill. So it's frustrating to know that regular order in Congress isn't actually happening.
So in fairness to Chairman Goodlatte, he does have his ideas on this issue that are just sort of very different from the Marketplace Fairness Act and other things that you guys would like. This sort of idea of taxation should, generally speaking, be based not on where the company or where the buyer is, but where the company is. Can you talk about whether you think that is a workable idea at all? If we are going to, being approaching legislation, whether that's something you could get behind, or there's something there that could happen.
No, I don't think it's workable at all. In fact, I think his proposal is not a solution to a problem, but a new problem in light of instead of the current problem. The consumption taxes, by definition, fall on the consumer, should fall on whoever's ultimately doing the consumption, suggesting that instead of the tax in South Dakota being premised on the purchasers in South Dakota who ultimately has the economic responsibility for paying the tax, but instead should go somewhere else, doesn't make any economic sense from my perspective. It also creates massive legal loopholes that would allow businesses to structure their affairs just like they do today, but in a different way, except it would be worse because now at least there's question about what physical presence means. If Congress enacted a statute, there would no longer be any question. You would simply need to fit within the four corners of the statute, and you would forever be exempt from having to collect sales tax anywhere.
Yeah, for a living, I work to find loopholes in order to save businesses money. That's what I do for a living as a tax person. So, what I would like to do is close the loophole on sales tax, and you open it, and that's destination sourcing. If you were to go to the origin sourcing, I can count on one hand within a few seconds how many loopholes we would open up, and it would not level the playing field. The way business is done today is it's not feasible to put it on where the business is located, because where is some of these online businesses? Where are they located? All you need is a laptop to sell something. You don't have to own any inventory. And in South Dakota, we have actually a GST tax, a goods and services tax. So when I do service, it's a taxable transaction in the state of South Dakota. So at what point, even though I might have a domiciled business in the state of South Dakota, but I provide services in some other state, now at what point, if my laptop is located in Washington, D.C., while I am doing a transaction for another business in Florida, again, you're opening up who is consuming the data and how do you tax it? I don't think we're closing any loopholes by going origin sourcing, because it depends on where you're coming from or where the laptop is located, not necessarily where the business is actually registered, because that doesn't mean anything today.
So I do think some of the questions the justices said today sort of explain sort of how we got to this point, sort of why the divide exists. And specifically today, that was sort of how much of a burden is this on businesses? How easy is software to use? How hard would it be for businesses to comply if they had to collect? The other one is sort of just the amount of money out there. There's this sort of question about whether or not, whether there's a lot or a little money out there and whether that matters. So I guess if you guys could just sort of dig into those two and sort of and how we got to that point and what that might mean for the debate.
I guess I'll start with the first question. I'll address, how easy is it? I will tell you, I set up entrepreneurial businesses all the time. It's very simple to register a business for collecting and remitting sales tax. Well, they say, well, that's not the point. If you're going to sell in multiple jurisdictions, how hard is that? Well, I will tell you, if you're in South Dakota and you're setting up a business and you're going to start collecting and remitting sales tax, the state of South Dakota has an agreement with Streamlined Sales Tax Governing Board. They have CSPs. All you do is you link the business into the CSP. It's a software company that you map your products. And to be honest, how many organizations other than Walmart are going to be a retailer going to be selling more than just a few items? I mean, obviously I've oversimplified it, but you map your products. If you sell shoes, you sell shoes, right? Mm-hmm. So your shoe salesperson jumps in, you set them up with their CSP, you map your products of where it's what type of product it is. So if you're selling shoes, you say, yep, I'm selling shoes. The software then determines for you which state you're going to do jurisdictions, and it's just a toggle on the software. If you're going to do business in South Dakota, Minnesota, Nebraska, Iowa, and North Dakota, they turn those on, and when you sell shoes into those states, it automatically generates the sales tax return for you and remits it. Now, because we're a streamlined state, that's for free. I don't have to pay for that as a business. It's simple, and it doesn't cost them anything.
And I think Justice Gorsuch, in his questions today, really highlighted, it's not a question of, is there a zero burden versus this new burden, because there are already many burdens that every multi-state enterprise is subject to. This is the only island, as Justice Gorsuch said in his 10th Circuit opinion in DMA versus Brohl, that is left. That business is still subject to regulation of the state in many different ways. And the burdens, to the extent that they exist, are much lower for all retailers than they were 15 or 20 years ago. And they are least of all on businesses who only sell online, because they don't have to integrate point of sale systems in their stores or anything of that effect. So is it burdenless? No, but is it a reasonable burden to impose on someone who's exploiting the marketplace? I think the answer is clearly yes. On the revenue side, it's a really difficult question because estimating noncompliance is always hard. You're by definition trying to figure out what's not happening. And so you've got a variety of different estimates, but even if you take the low end estimate from the GAO, which is what Wayfair's counsel was arguing today, that's still, I think, something like 4 times South Dakota's annual sales tax revenue. It's larger than the entire budget of the Environmental Protection Agency. So it's not a small amount of money. It may be only a few percentage points of sales taxes overall. It's about, if you take the GAO's low estimate, about 3% of total US sales tax collections. But that's about the average annual growth in sales tax collections. You get an entire year's worth of growth. And as Senator Peters said, it's not as if all states are simply going to take that money. Many states already have laws on the books that say if and when that new money comes in, they automatically reduce tax rates. Ohio, for example, I think it's income tax rates that would be reduced if additional monies come in. So it's not that states are simply looking for the new revenue. They're looking to protect their tax base so that they can control their own destiny in the future.
So I think, to discuss how we got to this point, especially on a federal level, the reason this is gridlocked on Congress is essentially because it's an issue that divides Republicans down the middle, probably more than any tax issue I've ever seen. Sort of on the one side, you've got people who would say this is a states' rights issue. We want to set up our state to rely heavily on sales tax, and so this is how we need to move forward. There's others who would say, expanding state power like this is essentially taxation without representation. It's that essentially that Republicans shouldn't be for anything that even, that doesn't pass the smell test of a tax increase. So can you sort of describe, explain your role in that, where you are on that, and sort of why you might think that would be a fake debate even?
I don't put a lot of stock in the conversation that this is a tax increase. This is a tax that people are legally owed and must pay. I don't know how many folks actually follow the law, but I'm one of those folks that actually files a use tax return every month because I I shop online, so I am going to find a way to be the person that pays use tax. I know I'm one of the minority in the country, but it is the law. It's just like the same reason that we don't go and excessively speed down the road. It's the law, right? You're not going to go in South Dakota, the speed limit is 80 miles an hour on the interstate. Now, some people do choose to go over the speed limit, but the majority of the folks are still going to be driving only 80 miles an hour. So as far as a tax increase, I would say it's not a tax increase. It's the law. People should be following the law. If you want to talk about all of the other laws that are on the books, it would be like our ag farmers in South Dakota who want to sell eggs or chickens to the state of California. Well, the state of California has a law on the books that says if they're not free range, you can't sell them here. Well, okay, so if you don't follow that law, you can't sell it in California. Why is that law any more different than sales tax? I mean, if I should be able to follow the same types of laws. If other states want to put up rules and guidelines on how to conduct business within their state, and you want to choose to do business in that state, doesn't matter how you buy it, where you buy it, or how it's sold, you should follow the laws of that state. That's the fundamental right of states' rights.
I also think this is really only a partisan issue within the Beltway. When you go outside and you look at the individual states that have jumped on board with streamlined sales tax from the get-go, that have, like Senator Peters, passed legislation, it is overwhelmingly a Republican issue. States like Wyoming, like South Dakota, Oklahoma, others, which are clearly not known as bastions of liberalism, are the states that have acted first on this. So when you go back to the state level and you talk to, certainly there have been Democratic supporters as well, but it really has been primarily conservative Republican legislators which have stood up in their chambers and said, we need to fix this, we need to level the playing field, because it is about our authority as a state to control our own tax base and about our ability to ensure that we have a level playing field for all who choose to exploit our marketplace.
I think it's important that states have the ability to protect business in their state. And this is one way to do it. Level the playing field to ensure that all businesses doing business in your state are following the exact same laws.
So can you talk about sort of when you might have gotten an inkling that this debate would take this path, that there would be a Supreme Court, the Supreme Court might act before Congress, and sort of, because it was not something that people were expecting maybe even just a couple of years ago?
I personally thought it would never happen. I told people for years the court has basically said it's done. It gave the Congress the ability by taking the due process issue off the table, which was in Bellis Hess, but distinguished in Quill. And then Justice Kennedy sent an invitation. And so at that point, I think it was fairly clear that it was time to begin thinking about an alternative path. And Senator Peters, to her credit, said, I want to go, let's do this.
That's exactly what happened. As soon as the door was opened, we went for it. And because we move so fast in South Dakota, we're small population. We have a great team in South Dakota. Our retailers are amazing. The legislators, literally, there was very little opposition in the legislature. We had no opposition in committee from anybody when we brought this piece of legislation. It was just us, and we pitched the bill. It took, I don't know, Sean, how long did it take us? 10 minutes to pitch the bill. There weren't any questions, and the only reason it didn't go on consent, I'm not really sure why, but literally it was a very simple process through the state legislature. And once we decided what the right path was going to be to do a direct challenge, once Justice Kennedy opened that door, we went for it.
And to do it the right way.
Right.
To make clear that there was not going to be any retroactive application,
Correct.
that you were not going to try to enforce a law that you knew was going to be subject to constitutional challenge, that you were going to protect all retailers as they went through the process. The amazing thing to me is that even though the law is voluntary, well over 100 retailers that weren't collecting before decided to collect. And back to the burden issue, of course, there were initially 4 companies that the state of South Dakota sued. One of them literally decided overnight to start collecting sales taxes, sort of giving lie to the contention that this is really impossible to do.
I mean, one of the things the justices said was that essentially that the law you guys created was essentially the best case, maybe reading between the lines a little bit there, and that the concern is that other states might not follow the best case. Is that how you did you construct this in a way that said, let's give the justices perhaps the prettiest face we can on this law?
Part of the reason South Dakota was kind of the perfect state to do this in is we don't have another tax mechanism. We are consumption-based taxes. So we're clean in that mechanism. The Senate Bill 106 was a direct challenge, so there was no facts behind the case. There was no audit of a business to create, and so you couldn't fight over semantics. It was a direct, head-on discussion as far as what the whole purpose was, as far as changing the game.
And I think I would change the description from best case to the right case. I think what Senator Peters in the South Dakota legislature attempted to do was to think through this and come at the right answer to the question so that the court would have the cleanest ability to review it and determine whether South Dakota's approach is appropriate. Because they don't have to bless approaches which have not been pursued or not been challenged. They can, and I know the next panel will get into this in more detail, look at South Dakota statute, determine whether it's constitutional, and then it will be up to other states to decide how they follow that.
The best case scenario is the Supreme Court justices say, you know what, let's do it the way South Dakota does it and make every other state follow the way South Dakota did it. You know, we've already simplified our tax laws. We have simplified our definitions. We have already coordinated with 24 other states with the Streamlined Sales Tax Governing Board. We already provide vendor compensation for our retailers to do their sales tax. We already work with online companies to help provide free software. If that's what the Supreme Court says it needs to happen, then do it the way South Dakota did it and affirm our laws. That's the right way to do it. We're the cleanest state as far as how we operate.
Okay. So I don't want to take all the fun here. Is there anybody in the audience that would have a question for our panel? If not, I have more.
They're tired. They were all
I
in line.
know. Everyone was waiting in line. That's true.
Everybody was up at 5
We were able to. Okay. So I do have another question, which is sort of I've heard you guys sort of talking about it's not as burdensome as some people would say. I've heard some people describe the idea of giving someone free software as giving them a free puppy. Essentially, that there's work that comes with that, and that sort of understates the burden of which is sort of what the defendants were trying to say in court today. Can you sort of talk specifically on that and sort of why that wouldn't be the case from your point of view?
Certainly, there is a burden to owning and operating a business, a regulatory burden, a tax collection burden. You're not shielded under Quill from corporate income taxes. Mm-hmm. Companies may not be paying them because they're not collecting sales tax and they may not think they owe those, but in most states they've already moved to an economic nexus standard for corporate income taxes. So there's that burden for that as well as other sorts of regulatory burdens. And again, I think the question isn't this or nothing, it's this or a Colorado-style notice and reporting regime, where you're still going to have to track everything. And it's not as simple as counsel made it out today. It's not simply sending a spreadsheet. You also have to notify the consumer on every transaction and provide each consumer with an annual report and let them know that that information has also been reported to the state. I know many folks here in the audience are probably familiar with the 1099 reporting regime for federal and state income taxes. That's not necessarily simpler than having the tax collected at the point of purchase. I think for consumers, because if you're looking at commerce on balance, the court's job isn't to protect businesses, it's to protect commerce. Is it really less burdensome on commerce to have every individual file monthly use tax returns than it is simply to pay at the time they purchase and for the retailer to aggregate that and remit it all to the state at the same time monthly?
I guess I have a hard time with anybody saying that the process is complicated. Very few businesses out there are like a Walmart or a Target, or a Best Buy. But Best Buy has focused on a variety of different things. They have the technology available. They already have the software available. They're already doing it today. But a small mom and pop shop is not traditionally doing what Walmart or Best Buy or Target does online. The small mom and pop shops, the folks that people really want to protect, are not selling 100,000 different types of products. They're selling individualized items, one here, one there, or they're selling jewelry, or they're selling cars, or they're selling shoes, or they're selling clothes. But once you have that mapped, it's not 100,000 different types of products. It's one product or 10 products or 20 products that are mapped in the system. It is not complicated to do the mapping unless you're an Amazon or a Walmart or a Best Buy, but they are already doing it today. Those big box companies have already developed the software in order to map all of the different products that they're already doing. They're already doing it today. If you want to protect the mom and pop shops from overregulation of all 50 states, you do it the way South Dakota did it.
And I think the argument may have had some truth 10 or 15 years ago when there wasn't such standardization even within the internet itself in terms of online shopping carts, right, where people were developing them themselves. But nearly every, especially if you're a smaller business, you're not hiring a software engineer to create a shopping cart. You're buying something off the shelf, and there are 5 or 10 or 15 vendors that integrate with every off-the-shelf shopping cart. And when Deb says mapping, not everybody may know what that means. That simply means look at what you're selling, look at what is, what the word is, say, yes, I'm selling this thing. And the software itself then says this thing that you're selling is taxable in this way in these states. You don't have to map it to every state. You map it one time. I sell shoes. Here's the description for shoes. I clicked that these things that I'm selling are shoes.
Okay, and I think that's gonna. So sorry. That's
right, no, it's all right.
That's gonna wrap up our first panel. And thank you guys.
Thank you very much, Bernie.
Thank
Aaron?
you.
Great. Thank you, Joe. Thank you, Senator Peters. Thank you, Bernie. We're going to take a 2-minute break, and we'll get the stage reset for the next panel. Okay, folks, if you'll take your seats, we're going to get started in just 1 minute. Thank you. Great. Well, welcome back. I'm pleased to introduce our next panelists to share insights into the arguments today before the Supreme Court and what will happen next. First, please welcome Deborah White. Deborah is the Senior Executive Vice President and General Counsel for the Retail Industry Leaders Association and President of the Retail Litigation Center. Under Deborah's leadership, the RLC and RILA have worked to bolster litigation efforts undertaken by several states to level the sales tax playing field, including, among other things, leading the amicus strategy associated with the South Dakota v. Wayfair. Prior to joining RILA and the RLC, Deborah was Principal of Regulatory Solutions, and prior to that, Senior Vice President and Chief Legal Officer for the Food Marketing Institute. Next, please welcome Eric Citron. Eric is a partner at Goldstein & Russell, specializing in Supreme Court and appellate litigation and counsel to the state of South Dakota on this case. Prior to joining Goldstein and Russell, Mr. Citron, Eric, how'd this get in here? Eric was a law clerk for Justices Sandra Day O'Connor and Elena Kagan at the U.S. Supreme Court. He also served as senior associate in the Supreme Court and Appellate Litigation Group at WilmerHale and as counsel to the Assistant Attorney General for the Antitrust Division at the Department of Justice. Please join me in welcoming back Bernie and welcoming Eric and Deborah to the stage.
All right, well, thank you guys for joining me. So we all sat through, or I guess you did more than sit through, technically, the arguments today. I guess sort of the broad question is, what are your major takeaways, and do you guys feel better or more confident post-arguments as you might have, or nervous as you might have before arguments?
I'll start. South Dakota has an outstanding case, clearly well thought out, built to give the Supreme Court an opportunity to reconsider the Quill rule, which is seriously outdated at this point. It includes lots of different pieces in it to ensure that everyone is treated well and is treated fairly. We think the justices were able to see that during the oral argument today, and we hope that they will perceive the case to be meritorious and to understand that the time has come to get rid of the outdated Quill rule.
Yeah, I mean, I think it's clear there are a lot of votes against Quill. Mm-hmm. There are other justices who are more concerned about what will happen if they get rid of it because they think they're embarking on the Wild West. One of the points that was made really well in the rebuttal and seemed to land on Justice Breyer in particular is that this is not going to be the Wild West, that this is just going to be the rule that's applied to every single other state tax or regulatory issue that's attacked under the Dormant Commerce Clause. That really seemed to land on him. And I heard both him and the Chief Justice searching for a compromise position that was offered by both the South Dakota advocate and by the Solicitor General's office that said, you don't have to say that anything goes. You can say that the South Dakota scheme is perfectly reasonable, and you leave for another day any state law that might be more onerous than that one. And I think that's the kind of solution that really appeals to the justices. It'll feel safe. It'll feel like there's very little risk of unforeseeable developments that couldn't be handled by the courts, and at the same time, they get rid of the rule that they know has served as an impediment towards making any progress in this space for 26 years.
For those of us who were there and those of you might read reports afterwards, I think this was my first time. And so if you could just sort of walk through sort of how to take justices' questions. I think there's some question about whether we should take that as their actual opinion on things or whether they're just sort of trying to sort of explain why justices might ask questions in the way they were and whether or not we should assume how much that suggests about their opinion on the case.
Sure. So reading the justices' questions is always a dangerous game. Mm-hmm. There's a couple of different things they could be trying to achieve. Sometimes they're trying to make one side or another's position look bad. Mm-hmm. I think that's generally the instinct that we have trying to read their questions. If they're asking tough questions to this advocate, they must not like his position. Mm-hmm. Sometimes, though, they're trying to get the advocate to agree that some kind of middle ground or less extreme position will work for them too. And that can come across looking skeptical, but is actually the justice is on board and is looking for the right kind of middle ground solution in the case. And that's going on a lot. And I heard that going on a lot of the questions today. Some of justices, if they're asking like 100 questions to one side and no questions to the other, you might correctly perceive them to be antagonistic to that legal position. But in general, you really shouldn't chalk too much up to it. And like when the Chief Justice asks questions of both sides, it's because he's earnestly trying to figure out what to do. Same with Justice Breyer, who was asking questions of both sides.
I think the other thing that's going on during oral argument is the justices are talking to each other. As I've learned from Eric and other people who've clerked at the court, the justices don't necessarily talk to each other offline or outside of the courtroom, and so they use that time in the courtroom to communicate with each other about their questions and what their positions might be. And so there's a lot going on sort of behind the scenes with those questions. We perceive them as to be just to the advocates themselves, and of course they are to the advocates, but there's communication going on at a lot of different levels during oral argument.
Mm-hmm. So, I mean, you said that you thought they were sort of maybe grasping about for potential compromise. There was also a lot of talk about, yes, it's been 26 years, but, are we really the right vehicle for making a decision on this? Should we allow Congress more time? Can you sort of talk about, how seriously to take that, the idea that, maybe this isn't sort of the path we should go down?
Yeah, I mean, I think part of what's going on is that it may be a unanimous point among all the justices and both the advocates and all the amici in the case that the best solution would be some kind of compromise solution emerging from Congress. And the right question is, okay, well, how do we get there? And you saw even Justice Sotomayor who appeared quite skeptical of the state's position, saying, how do we send a signal to Congress that we want them to do something about this? And so the question isn't, should Congress be the one who could do something about this? Because no matter who wins, Congress can do whatever it wants in this space. Mm-hmm. The question is, assume that Congress does nothing, because Congress often does nothing, right? What happens then? Mm-hmm. And the state's position is, if Congress does nothing, then the ordinary powers that the states have for every other tax, every other regulatory obligation should be the same one that applies here. And if it turns out that any of the hypothesized problems actually arise, if states pass laws that are radically different, much more burdensome than South Dakota's, that's when Congress would step in. But until that happens, Congress doesn't have any incentive to do anything because the states aren't going to be pushing the envelope, and we don't even know if they would. We don't have the background against which Congress would usually act. That's the problem.
I think the other thing is there's a lot of skepticism expressed today. There was certainly a lot of support for Congress, and as Eric says, pretty much both parties in the amici agree that there are certain things that Congress should do, but where Congress starts to act on that depends a lot on what the default rule is. And until the court corrects its mistakes, which was very clearly expressed by several justices today, there's a lot of recognition about the problems of Quill and the need to correct an incorrect rule. And the question is, who does that first, right? And clearly, Congress hasn't been able to act for 26 years in the face of this rule. So the court, I think, and there are a number of justices who recognize that it's important for the court to clean up its own mistakes, to fix the playing field, the legal playing field, and then let Congress act. And I think that would be the appropriate order of things.
Mm-hmm. So one of the things the justices said, and I think they would say, as some of us would say, that sort of trying to predict what Congress would do is at times a fool's errand. But they brought up several times the Microsoft case, which they announced today, which was basically, we heard something, Congress acted before we could act, and so great. And then they sort of view it as like, well, is there potential to do that in this case? Should we, because that was decided to announce today and is sort of fresh in their mind, should we put any more credence behind that just because of how fresh the Microsoft announcement was?
Congress has had 26 years to act, and they just haven't done it. And I think it's really important that the court first level the playing field, clean up its mistakes, and then Congress will have a better opportunity to act.
Okay.
Yeah, I think the one thing that's going to happen for the justices as they're thinking about the case is try to decide if this is a situation where Congress can be expected to do something, or if Congress's inaction is the more likely result, in part because of the rule that Quill sets. And one of the things that's really clear from the briefing is that there have been compromise bills that have made it through the Senate that have broad support in the House and aren't coming up for votes. And I think if the justices are alive to what's going on, they're very unlikely to take the position, for example, that Congress is really behind the current regime. Mm-hmm. I think they're perfectly well aware that Congress's inaction can be rooted in a lot of different things. And so I think there'll be some skepticism at the end of the day that Congress is going to act on this issue. In Microsoft, it was a very different situation. You had a bill addressed to this problem, which had arisen just for the first time and was moving quickly through Congress. That 26 years is much slower than that.
Right. And of course, we have members of Congress on both who've weighed in on both sides of this case, both asking the court to wait for Congress and also saying we can't act until you act. And so I think when you look at the balance, that sort of they at least cancel each other out.
So, one of the, and I think I asked this to the first panel, but I think I'd love to hear your perspective on it too, which was, I think we specifically heard this from Justice Breyer, was this idea of, one side is saying this is not going to be a burden. There's software for companies. This is, states are desperately in need of this revenue. And you saw on the other side saying it's not as easy as they say it is. This is essentially, more and more revenue is getting collected. You're getting as much as 95% of the big retailers are collecting in states. They're overstating the problem. And you saw Justice Breyer saying, like, those both sound logical to me. Which one of you is right? And is that a common thing for a justice to say in that sort of case? And sort of speak to what you took from that and what that might mean sort of for an actual decision.
Well, one thing is really clear, which is that it's nice to be a Supreme Court justice because you don't almost ever have to deal with actual facts and like figuring them out. And as a result, facts often make Supreme Court justices like feel very uncomfortable. They're like, oh, am I supposed to find out what's really going on? That's not my job description. But I think the key facts, correctly interpreted, are actually agreed by the parties and demonstrate the state's argument is very strong. It's true that like 80% of the tax is being collected. And I think that that's good evidence that this is not an unsolvable problem or a too difficult burden on companies. Wayfair, Newegg, Overstock, their competitors can all do this. Mm-hmm. They do it in lots of states, right? At the same time, we know the states are out $100 billion over the next decade. So it's not like this is a small or vanishing problem. It's a big deal, even that small piece that's going uncollected, right? So all you really have is a special tax haven, essentially, for a small set of companies, not who can't do this, who just don't want to, because they get to look like duty-free shops as long as they're not doing it. And those aren't disputed facts. Those are the respondents' facts. And so I'm hopeful that the court perceives those facts correctly and gets to the right place.
And this is a real problem for retail. I mean, e-commerce is growing, and as both sides have recognized, there is some merging going on, some converging. But until that happens, it's really important that the court clean up the legal playing field here. There are a number of briefs submitted by independent retailers that showed that consumers come in and they get the advice from that, they get the help from employees in local stores, and then they correctly maybe make a judgment about what it's actually going to cost them to purchase that large screen TV or that leather sofa at the furniture store on Main Street versus buying it online where they perceive it to be a duty-free sale, and they may not know, or maybe they do know and they don't want to pay the tax. But it's not fair to disadvantage that local store who's providing basically services for the online retailer. It's not fair to disadvantage that store, and so again, it's time for the court to act.
I'll say one other thing that I think is relevant, which is it's really easy in the context of the oral argument to talk about, well, how burdensome is this, and how hard is it, and isn't this going to be really difficult on small sellers and the like? And what you just lose track of is the fact that the court's existing rule doesn't have anything to do with any of that, right? If you are a very small seller in one corner of Texas and you have a website, and the respondents say 90% of small sellers have a website, you have to collect in all 1,500 tax jurisdictions in Texas because it's not sensitive to your size or whether you're a big store or a little fish. It's just based on this totally arbitrary fact of physical presence. If you do business by having a traveling salesman, you have to figure this out in every state in the country. If you do business without a traveling salesman, you don't have to. That doesn't have to do with how burdensome it is or anything like that. It's just a random rule we have from an old era. And it's easy in the context of argument to forget that. When the justices go back to chambers, they have to try to defend the existing constitutional rule. Whatever they're thinking about saying, it's a lot harder to say, oh, well, we really ought to keep a physical presence rule because we're worried about all these burdens.
Okay. So Eric, you talked about how it seemed like the Chief Justice particularly might have been looking for a compromise. I think to laymen like me, that seems to be a theme of his tenure, right? Was that, narrow when possible, how much should we take that into account when sort of trying to maybe not project, but sort of understand where this court might land on this particular case?
Well, look, I think courts decide cases and not issues, which is part of what makes a case like this one so weird. Because Quill is a case that isn't really about that case. It's about setting a nationwide rule. But they have in front of them a case about a statute that is very reasonable. And the ordinary thing for a court to do is to evaluate the statute that they have in front of them and say, does this seem reasonable or unreasonable? And so it's a really natural solution to the case to say, we're wrong about physical presence. We have in front of us a statute that takes great pains not to impose heavy burdens on out-of-state sellers who can't deal with them. This we know is constitutional, and we'll figure out the next case when it comes. So because that's such a natural thing for a court to do, I think it's something that can be expected. And you heard both South Dakota and the Solicitor General saying, look, that's probably the best way to address this case. Just handle this statute and then leave for another day problems that you're more concerned with.
Okay. So I'm about to go sort of far afield my area of expertise, which is always a good sign. But so, there are other cases before the court dealing with state power, and there's public sector union case. There's all sorts of similar areas where the court needs to decide, like, where's the correct level of state and local power. How should we view this case within those cases, and what the justices said today? I mean, are they sort of casting about for how this fits in the sort of the broader context of other cases they have to decide? Or is there anything we should think about on that front?
I think the justices are aware of the other cases that are going on, and they decide everything sort of within the context of the broader picture, for sure. But given the very reasonableness of the statute in front of them, the oral argument, there's a lot of excitement in the air. There's a lot of energy in the air as the justices ask questions and the advocates respond. But when the justices go back to their chambers and think about this case more clearly and sort of just this case alone, they really do have a good opportunity to look at South Dakota's law and say, okay, this really is a very reasonable solution to this particular problem. I think the briefing also tees that up very clearly. It draws distinctions. Perhaps it doesn't point out, well, don't look at this other case, but it very clearly talks about, how the doctrinal underpinnings of this particular area have really narrowed over time. I think the justices, when they look at that and they think about some of the other cases that they have on their docket, they'll see that this really is a more unique and narrow and distinct circumstance where they can decide this case without necessarily upsetting a whole doctrinal apple cart in a bunch of other areas.
Yeah, the funny thing about Quill, right, is that it is a rule that applies to no other Dormant Commerce Clause challenges, no other taxes, no other regulatory obligations, and so has literally no application to any other legal question. And so that gives the justices a lot of opportunity to narrow this case to just this one issue, if that's what they want to do. I do think they are aware of, some meta concern, what we would call a meta concern, like overruling precedent or something like that. But even that they could cabin to this circumstance by saying, look, this isn't really about whether we thought we got a case about mail order right 25 years ago. This is about a phenomenon that did not even exist the last time we talked about this issue. And that means we have, a very different set of changed circumstances on our mind, and we're not just reconsidering a legal question that our colleagues decided differently before. I think that makes a big difference.
Okay. One of the concerns, or one of the questions you heard, at least from, I think, Justice Sotomayor, among others, was that, say we rule this way and it finds out that there is hardship on small businesses, and then they have to challenge again, and then it's a couple years before maybe we hear this again. Is there anything that the court can do to sort of try to get in front of that, to sort of, prod states to enact laws like South Dakota, or to send some signal to Congress to act, as the justice also said? Is there any way in a ruling that they can sort of try to steer states and Congress into sort of some sort of action that would limit those concerns they had?
I think a strong endorsement of the South Dakota law and all of the reasonable parameters and guardrails around it would send a very strong signal to the other states about what what the court, thinks is constitutional. And if you look out over the landscape today, a number of other states have already enacted those types of laws which have reasonable thresholds. One of the questions that came up today is, how can we, the court, set what a reasonable threshold is? But if you look at, South Dakota's $100,000 threshold, Tennessee's $500,000, Alabama's $250,000, and you consider the size of the economies in each of those states, and then you scale them up to a national number, they come close to a pretty even national number. I think the number we've used is about 25 million in national sales. So that's a big number of sales. Those are large, sophisticated companies. And if the court recognizes that South Dakota's law is constitutional, regardless of which path they take to get there, if they uphold South Dakota's law as constitutional, and they recognize in doing that it has a lot of features that make it acceptable to the court, such as a reasonable threshold limit, the fact that it's not retroactive, those sorts of things, it's likely to encourage other states to follow suit, particularly since so many other states already have laws like that on the books.
Yeah, I'm just a strong second for that position. I think the best way to encourage states to do reasonable things is to uphold a reasonable statute. And they know that. And that's why what the Chief Justice was asking was, could we say that this meets a constitutional minimum, that there is some minimum that's not one sale, and leave it at that. And, both the government and South Dakota said, of course you could do that. And, the Supreme Court can do whatever it wants. But, that's a very strong message that this is the model you ought to follow. And I'm quite certain that's what would happen.
Sort of putting aside for a second, if we can, the president's own relationship with Amazon, the fact that his Solicitor General,
What?
Exactly right. Have you heard of it? Twitter. It's Twitter, yes. The fact that his Solicitor General was on South Dakota's side, and what sort of impact does that have to the justices? And should we read anything out of that he was sort of basically simpatico with South Dakota?
The Solicitor General is often referred to as the 10th Justice. And partly what you could see in Malcolm Stewart's style is desire to just be very accurate about what the constitutional law precedents say, as opposed to taking an advocate's position on everything. And I think for that reason, the most important aspect of the Solicitor General's support isn't like the administration's position, but instead the kind of neutral, disinterested take on what the law ought to be. And that's particularly true here because there isn't actually a strong federal interest in the case. It's not like it's going to cost the United States a lot of tax dollars one way or the other. And so when the Solicitor General participates and says, no, look, this is really the right rule and what you ought to do, the court sort of views that as a disinterested, neutral arbiter saying, look, this is the right result. And that can be very persuasive.
What do you think about it, right? This is about the Dormant Commerce Clause and the scope. And so what that's really about is, what the state's powers should be vis-a-vis Congress. So the administration really is sort of a separate entity to all of that. So the fact that, as Eric says, the SG is coming in and saying this is the appropriate balance is very helpful. It's going to be helpful to the justices. And we think it was important for them to join South Dakota's side in this.
We'll give this another try. Is there any questions in the audience? I think we do have one right there. Oh, I think there's a microphone coming.
Thank you. Picking up on the Solicitor General's argument, it seemed like he was trying to offer the court an opportunity to get to the correct result without overturning Quill by saying you don't have to reject the underpinnings of Quill in terms of there being a requirement of a nexus. All you have to do is reject the label that's really outdated, which is the labeling of that requirement of a nexus as a requirement of physical presence. Did you think that landed well with any of the justices?
That's for sure what they're trying to do. They're trying to say, look, you didn't think about this at all at the time that you called it a physical presence rule. It was just a shorthand for the mail order business model that you had in mind at the time. And I think that did land on the justices. You saw there wasn't a lot of skepticism of that position. You saw a kind of body language result that was like, of course that's right. We certainly didn't have, or our colleagues certainly didn't have anything like this in mind. The question is whether that helps, whether it's the kind of thing that a justice might feel comfortable putting in a concurrence as a basis to vote for a position they wouldn't otherwise take. I think there are justices for whom stare decisis is a big deal. That is, it's a big deal to them that there was a case about this before. And what the Solicitor General is trying to do is offer them a way to vote for what they must know is the right result without endangering that principle. So I think there are some people who will be thinking about it, but it's hard to say if it'll make the difference.
And to that point, I'd just add, the Solicitor General says, first and foremost, you should uphold South Dakota's law as constitutional, and that's the bottom line, right? Which of the three paths or other paths the court ultimately takes to get there in terms of giving good guidance to the states, and of course, in terms of sort of leveling the playing field, upholding South Dakota's law as constitutional is the most important things. They're going to have to abrogate the physical presence rule in order to get there, but the exact course that they take is less important. And so to see the Solicitor General come out with that strong affirmation was really important.
Anybody else up there? Anything? Okay, so I'll ask, Deb, this one's more for you. One of the things the defendants were saying was sort of that this would be, if the court sort of sweeps away Quill without any sort of, regulatory framework put in place by Congress, that it will be chaos, was the term they used. Can you just sort of, I guess, push back on that if you think that that's not true?
Sure. Again, I think the court isn't just going to, if they decide that a change is needed or their rule is outdated, they wouldn't just sweep away the rule and leave that chaos. They have this opportunity because the South Dakota law is so clear to say, and as Eric said before, they like to rule on the case in front of them. So if they rule on the case in front of them, they're not just going to be abrogating the Quill rule, but they'll abrogate the physical presence rule in the context of South Dakota's law, and they'll say that that old rule doesn't apply anymore, but this new rule does. This makes a lot of sense. And you think about it, Eric talked before about the physical presence rule and how that leads to very arbitrary results. You can have, somebody going on vacation to Mount Rushmore and consummating a sale, but that doesn't give that person any more knowledge about what the tax laws are and how to comply with them than somebody who has a business, has a store in one of the jurisdictions. So the physical presence rule doesn't work for a lot of reasons anymore, and the economic presence rule, which is really the way to think about South Dakota's law, where it says it doesn't matter whether or not you've got a store in some corner of the state. What's important is how much business you're doing in our state. So if the court, in the context of seeing this case, decides that physical presence really doesn't make sense anymore, they're not going to say that there's nothing out there whatsoever. They're most likely to say that the economic presence rule, South Dakota's law, makes sense, and that will ensure that that there's reason and rationality that goes forth in the future. And the states are not interested in chaos. The states are interested in collecting the monies that are owed. And so if the states have an example of a very simple, workable rule, they're likely to adopt that.
Yeah, so I just have to say, because I can't help myself, that this chaos thing is like a total boogeyman, right? Like, Wayfair's competitors already do this every single state. 50% of the top 1,000 internet retailers are already collecting in all these states. There are 33 different providers of the sales tax compliance software that will help you do this. They all have competing business models with low marginal costs that are driving this kind of the cost for those systems down. This is not going to be chaos. It's going to be exactly like it is right now for all the major retailers. It's just a thing that you say when you're trying to scare the Supreme Court out of changing its existing rule. And I think anybody who just interrogates their common sense for one moment knows that this kind of problem is exactly the kind of problem that large internet retailers solve every day. They can tell you in an instant how much it costs to ship every single product that they have based on its weight, height, dimensions, perishability, fragility to any given address in the country, like at the literal click of a button. If they can figure that out, they can figure out taxes too. It's way simpler, right? It's just something you say when you're like, oh God, if you change the rule, the sky will fall.
Sort of broadly speaking, we talked about the sort of danger of trying to read too much into what the justices say, but was there anything today that surprised you, and what might that mean for a decision or for, a sort of a post-Quill world or a world where, there's a narrow uphold or a world where Quill survives?
I was very pleased to see Justice Ginsburg's line of questioning and her real concern about the problems that an incorrect rule from the court could have and how that impacts Congress and about what the court's duty is in that situation. And I was pleased to see that. I mean, we knew going in, Justice Kennedy has written on this. He wrote the concurring opinion that invited a challenge in the first place. Justice Gorsuch has written on this. We know that Justice Thomas is skeptical about the Dormant Commerce Clause. And I had understood that Justice Ginsburg might have some concerns, but to see her line of questioning from the beginning of the state's argument all the way through the end, sort of to keep pulling back and reminding the advocates and her colleagues about their obligations and the power of where they set the default rule on how Congress acts. I was pleased to see that.
Yeah, to be perfectly honest, I didn't.
No is a fine answer, right?
I didn't find it very surprising. If you had come to the moot courts that we did to try to prepare General Jackley for the argument, you would have seen almost all the exact same questions posed and real work on what the right answers ought to be. I think we sometimes have an uncanny ability to predict what the justices are going to be worried about based on the briefing, and I think you saw all the same concerns there. But at the same time, I think you saw a recognition that, as Justice Kennedy was pointing out, the premise of all the questions is that Quill is actually wrong, and they're going to have to wrestle at the end of the day with whether they really want to keep something that they know is wrong, just on the theory that maybe Congress or somebody else will fix it eventually.
Yeah, and I would agree with that. There were no questions raised that we didn't anticipate or think that the justices would raise and ask questions of in different contexts. They asked difficult questions to sort of probe what the parameters are. So the questioning, I agree. There were no real issues that were surprising. It is sometimes illuminating to hear the direction behind a justice, and I wasn't sure exactly where Justice Ginsburg would be, and it was nice to hear her line of questioning.
I don't think there's a person on earth who can predict exactly how Stephen Breyer is going to ask a question, but what is going to be on his mind is probably something, you can see coming.
And I thought his questions were pretty narrowly tailored today. Sometimes they can be far longer, and so the fact that he asked for 3 things from General Jackley, I thought that was very helpful.
So sort of as we've noted, sweeping away Quill and upholding the South Dakota law aren't necessarily the same thing in this case. They could be, but they don't have to be. Sounds like you at least seem confident that there's 5 votes to uphold the South Dakota law. Is that fair?
Yeah, I think they're going to be very positive on the South Dakota law. And I heard both the chief and justices like Justice Alito saying, can we just say there's a minimum and that we like South Dakota's law? And you heard both the Solicitor General and South Dakota pressing for that result as well. I think that's where they're going to end up.
I think when you go back again and you look at the strength of this case and how it was developed, all the thought and care that was put into the legislation at the beginning, the respect for taxpayers, the insurance that nobody would be unfairly disadvantaged, the fact that the state agreed up front not to go retroactive on this, the very respectful minimum sales threshold, and the quality of the briefing all the way through. I think when the justices look at that as a whole, that makes me cautiously optimistic that we'll get to the right place.
Okay. So unless there is another question from the audience, that seems like a pretty good place for me to cap it off. Everyone okay? We're all good? Okay. All right. Thank you, guys.
Thank you very much to our panelists. Thank you to our moderator, Bernie Becker. Thank you to all of you for making time for this. It's obviously a very important case to the retail industry, and really do appreciate your interests. One important reminder, it's tax day, so make sure to pay your use taxes today. So, thanks, everybody.